What I'm going to be doing first, Nanchang, is I just go through what this is about, the conference. So, Nanchang, what you have to tell us is about the conference. What is the conference about? Nanchang? Yes, Nanchang. What is this
Can you,
conference about?
hello, can you hear me?
Yeah, I can hear you.
Okay.
So, what is this conference, Nanchang?
Yes, the topic.
The conference. What about the conference? Tell us about the conference.
Okay. This is the conference about world mediation, and we are were the World Mediation Conference Vision 2020 is about the evolution of mediation and mediators. It started on the 18th of May and it's ending on the 30th of June 2021.
2022.
We have
Nanchang 22.
yes, 2022 is yes 2022, and then we have the opening session by Ken Cloke, and we use that to mark his birthday. I think that's
Perfect. Okay, great. Because that's also important that you tell me about the conference. So now, Nanchang, you have to tell us about yourself, and you have to tell us this, what you're wearing is from which part of Nigeria?
Well, my name is Nanchang Nangwang. I am a lawyer. I'm an ADR practitioner. I am the principal partner of N. Nanchang and Co. I am the founder of Settlement House Nigeria. Settlement House is an ADR institution that is into coaching, training, certification, consultancy, and practice of alternative dispute resolution. I've been practicing for a while, and I am actually happy to be here. Yes.
Great. And what about you telling me about what you're wearing is from a specific part of Nigeria, or?
Yeah, this what I'm wearing is a native clothes, actually from Nigeria, but particularly the people associated with this kind of clothing is the Yorubas in
Yorubas.
Nigeria. But yes, it's not actually exclusive to them anyway. That's why you can see me wearing it. It's a mark
But,
of identity.
but which part of Nigeria are you from? You said?
Yes, I am from Plateau State, from Lantang North local government specifically.
Okay.
Of Plateau State, yes.
Perfect. So basically, mediation versus conciliation. So for only thing, my only thing, Nanchang, is you said settlement house is into ADR. We want to move you totally to mediation, not general ADR. So that is what the aim is going to be that.
Yeah, okay, fine.
Okay, so Nanchang, mediation versus
Yeah.
conciliation, what are your thoughts about that?
Okay, well, I don't know. Can I be able to share a
Yeah,
screen?
please.
Okay. Okay. Can you see my
Yep.
screen?
Yep.
Okay, well,
You just might have to just start the slideshow. Just go on the slideshow on top or bottom, whatever. If you just click on the top there is a slideshow.
can you see the
No,
slide?
if you start the slideshow, we'll see it bigger. So if you can either go on top, there is right on
Okay.
the just press slideshow on top, or
On
there's
top?
on the top you see slideshow written there. Can you see on top
Okay.
slideshow?
Slide control.
Slideshow right on top there is home, insert. On top of that, or there is actually an icon at the bottom. I'll show you the icon later. Can't you read the home? See here.
Okay.
If you just start the slideshow and you share the screen, we'll be able to see a bigger slide.
Oh, I would have been okay if I click on this.
Just start the screen share and then we can do it.
Okay. Okay.
I'll tell you what. I've asked you for the remote. I'll do it. Just
okay.
If you just give me the remote, I'll do it. Just click on that button.
All right. Is that right? Okay. Is that okay?
Yeah. One second.
Okay. All right.
Then you'll have to just leave it. You'll have to just one sec. You'll have to just. You don't have to do anything. I'll do it.
Okay. Okay. Great.
After this, you are going to take the slides. Yeah, please.
Okay. So, are we? Okay, that's good.
But that's so good. Why did you change that? Let's see you. Where do you got yourself out? But next time, Nanchang, I want your next picture has to be in your traditional clothes.
Oh, that would be fine.
Because we're trying to say that, look, we're trying to say that it is an informal process. So let people connect with you. If from it, yeah, exactly.
Okay, that's I'm dressed informally, isn't it?
Yes, the guy, you'll scare the people in mediation. Say, oh, he's going to decide for us. It seems he knows everything.
All right. So can we now go ahead?
Yes, please.
Okay. So how many minutes do I have?
Take your time. Take your time. No problem at all.
Okay. Okay, that's fine. That's fine. Okay. Well, I want to start by maybe a little foundation and background introduction to the topic, mediation and conciliation. Well, I will say that, disputes in our society are inevitable. Inevitable because as humans interact with one another, one way or the other, dispute arise. And then we know that one of the major way of resolving disputes that we all know is through the court system. That's through litigation. But we also have another way of resolving dispute, which is ADR. ADR, before we've known it to be alternative dispute resolution. But I put appropriate here because it is actually the appropriate dispute resolution. So now, mediation is one of the alternative ways of resolving dispute, or one of the appropriate ways of resolving disputes. And we can see here that mediation is not popular in most parts of our country as a means of resolving dispute because of certain misconceptions. One of those misconceptions is the fact that the fear that mediation or settlement agreement reached are not binding or enforceable. That's one of the misconceptions. And then the second is that there are no laws that are made regulating mediation, just like arbitration. That's one of the second part of the misconception. So, but I discovered that most countries in the world actually have the Arbitration and Conciliation Act. So if that's the case, mediation and conciliation, are they actually the same or different, or can mediation come under the Arbitration and Conciliation Act? Now, many people have attempted to distinguish between mediation and conciliation. And maybe that's one of the misconceptions as well, because people don't see mediation as conciliation. So we know there's Arbitration and Conciliation Act, but we don't have Mediation Act. We don't have something specifically or peculiar to mediation. So An attempt to define most of these things, as suggested by many people, is the fact that a mediation is suggested to be about resolving disputes between parties with the help of a third party appointed mediator to help and support both parties in coming to an agreement. Now, conciliation is also looked at as is said to be an alternative dispute resolution mechanism in which a third party is appointed to help settle the dispute by persuading both parties to reach an agreement. So if you look at the definitions, you may not be able to actually separate them per se, except maybe as we go on, we'll get to see what this is all about. So what is the role of a mediator? What is the role of a conciliator? For example, if we're going to look at this factor. So a mediator's role is to facilitate mediation session, while the role of a conciliator is to facilitate evaluate and intervene in conciliation sessions. So we can see that both mediator and conciliator are actually third parties appointed with the consent of the parties to help in the resolution of the dispute. So most countries of the world have the Arbitration and Conciliation Act. So now the question is, does the Arbitration and Conciliation Act applies to mediation, or is mediation a part of conciliation, or are they the same? These are the questions that we are going to be looking at in the course of this. So let's look at the Arbitration and Conciliation Act in Nigeria, for example. I know that most of the Arbitration and Conciliation Acts that the Arbitration and Conciliation Act of Nigeria is actually similar to most of to that of most countries. So we see that the role of the mediator, mediator in conciliation, in mediation, and the role of a conciliator in conciliation are actually, I don't know the word to use. They are not actually something that can be separated or distinguished per se. So conciliation is defined according to the etimonline.com as any of the various forms of mediation, whereby disputes may be settled short of arbitration. So this is an online definition provided that conciliation is one of the various forms of mediation. And as long as it is not arbitration where a party has the power to impose a solution or give a kind of a verdict, as long as the decision remains that of the parties, it is mediation. So the English dictionary defines conciliation as the action of bringing peace and harmony, the action of ending strife. Now, the second definition is given as a form of ADR similar but less formal than mediation, in which the parties bring their disputes to a neutral third party who helps lower tensions, improves communications, and explore possible solutions. So if you look at this definition, this is a definition of conciliation as given by just a dictionary. So the Merriam-Webster's dictionary defines conciliation as making someone more friendly or less angry. Just, I want us to picture mediation and conciliation. Let's just have a mental picture of some of these definitions and see whether mediation and conciliation are actually different or the same thing. So Merriam-Webster defines it as what I just stated, and then the World Web Dictionary defines it as any of the various forms of mediation whereby dispute may be settled short of mediation. So this is a repetition of one of the definitions I've mentioned earlier. Now, when we look at the Oxford Advanced Learners Dictionary, it defines to conciliate or conciliation as, okay, to make somebody less angry or friendly, especially by being kind or pleasant, or by giving them something. Another definition is that it's to help settle disputes between employers and workers. Then the third one is a conciliator is a person or an organization that tries to make angry people calm so that they can discuss or solve their problems successfully. Now, does this differ from what a mediator does? In the course of it, we'll get to know. Now, according to the Oxford Advanced Learners Dictionary still, to mediate, what does it mean? It says is to try to end a disagreement between two or more people or groups by talking to them and trying to find things that everyone can accept, that can agree on. That's to mediate. Now, who is a mediator? According to just the dictionary, a mediator says, according to the dictionary, it says a person or an organization that tries to get agreement between people or groups. So that's a dispute. That's who a mediator is according to the dictionary. Now, I said earlier that we're going to use the Arbitration and Conciliation Act of Nigeria and see whether this conciliation, the conciliation aspect of the Arbitration and Conciliation Act, whether it's actually a law that regulates mediation. Because as I go through the Arbitration and Conciliation Act, I see the provisions that were made in respect of conciliation. They are more or less the same for mediation. Now, for example, let's look at the ACA, Laws of the Federation of Nigeria 2004. Now, it says that the conciliation rules applies to conciliation of disputes arising out or relating to a contractual or other legal relationships, where parties are seeking amenable settlement. That is the essence. Conciliation, mediation, parties are looking for amenable settlement of their disputes. And they have agreed that this conciliation rule should apply. So parties who have disputes and they want to settle their disputes can decide to say, oh, let us make the provision of this act applicable. And when it is applicable, the parties now appoint who is going to conciliate or who is going to be a mediator. Now, the parties may agree to exclude any of the rules. That's still, mediation is party dependent, as in independent of the parties. The parties play a very great role in the process of mediation from the beginning to the end. They are involved. That is what also happened in conciliation. The parties are the ones that are the determinant from the beginning to the end. So what is the difference? Is there actually difference, or is just a misconception, or maybe ignorance on our part for us to promote the idea that, oh, mediation is not actually regulated by any law per se, especially in Nigeria. So parties may agree to exclude the provision of the rule, so anyone they feel, except if it is in conflict with any existing law, but the parties can say, oh, this rule, conciliation rule, this particular one is excluded. That's the right of the parties. Now, everything in conciliation, as we can see from the ACA, is dependent on the parties, starting from the initiation of the conciliation process. Just like mediation, it is the parties that initiate the process. One of the parties will have to intimate the other party or write to the other party, oh, let us go for conciliation. and there must be an acceptance on the other side of the parties. And that is what happens in mediation. Nobody forced anybody. We said parties are free, and one is freedom is one of the important ingredients of mediation. The parties will have to agree to come to the table. Although there is talk about mandatory mediation, we are saying that mediation has to be voluntary. And conciliation also, we can see, is voluntary. The parties decide, they initiate. The other person will have to accept and say, yes, let us go for this. And then we also see that the number of conciliators, it can either be 1 or 2 or 3, depending on what the parties agree on. The parties can also decide to engage an institution, an ADR institution, to say, oh, appoint someone or suggest a conciliator for us. The same thing with mediation. So I just want us to be looking at, is there actually a difference, or does this law actually make provision for mediation? And then maybe we're ignorant of it. Now, we can see that the parties can agree that one person should conciliate, and then if they agree, that's fine. They move on to the conciliation session. And then if they don't agree, and then or they decide to say, okay, let us have 2 or 3, where there are 3, each of the parties of the disputants will have to appoint one person as a conciliator, and the other person will be appointed by the other disputant, and then the 2 appointed conciliators will now appoint the 3rd one. So parties also submit their statement of dispute, just like in mediation. You state briefly what the dispute is all about, what you are asking for, your claims. That is what happens here too. You submit it to the 3rd party, who is appointed as a conciliator or a mediator. Now, Mr. Vikram, are you hearing me?
Yeah, absolutely. Perfectly all right.
Okay, that's good.
Going well, you're going well.
Okay. So
I'll come in only when you finish, so no problem. We could have said hi to Isaac because he had come in. He's there. He's put his video.
Yes, Isaac. Yes. Isaac, how are you?
Isaac, what he does is he logs in and then he disappears. We feel that yes, Isaac is there, but he's just recorded his attendance. That's all he's done.
No.
Isaac, is that true?
What do you say, Isaac? Isaac's he's got some internet connectivity issue. No problem. You go ahead. We'll get him in later.
Fine.
We'll get him in later.
Fine. Okay.
Hello.
So now,
yes, I'm back. Can you hear me?
Yes. Now we can hear you.
Yes, I'm here. My power went off. That's why I put my video off. But it's back.
Okay.
No problem. We'll get you in later after Nanchang finishes presentation. Then please you have to come in and give us your thoughts also.
Sure.
So that's why you have to keep listening.
Yes. So today I'm here.
Okay. Yeah. Welcome, Isaac. Okay. So you can see that parties may decide to be assisted by a person who will represent them or offer assistance. In mediation, we have people who are trained as mediation advocates. Mediation advocates are actually persons who represent people in mediation sessions. So also, the Arbitration and Conciliation Act makes provision for such people. Or, you can also say, oh, I want to bring in my pastor, I want to bring in my friend, I want to bring in 1 or 2 persons, and then as long as the parties agree upon, fine, that is good. So you can see the Conciliation Act makes provision for that. Also, according to the ACA, what is the role of a mediator? We can see it. Is it different from that which the mediator, the role of a mediator? You can see it says it assists the parties independently and impartially to resolve their dispute. It assists them independently and impartially. So the conciliator does not side with one party, does not show any form of partiality. He is there as a neutral 3rd party to assist the people to resolve their dispute. Now, he also conducts the proceedings according to the circumstances of each case. every case is peculiar. That is why at the inception, the parties to the dispute will submit their statement of dispute, stating the facts, the circumstances, and what they are seeking or asking for. So they submit it to the conciliator, so that the conciliator will actually look at it and then know how to approach it independently, depending on the circumstance of the dispute. Now, parties wish or decision on the use of oral statement and or may decide to set time for speedy resolution of the dispute. Now, you see, one of the advantage of ADR, as we have been saying, is that it allows the parties to actually be involved in the resolution of their disputes. Their involvement may in terms of in relation to this, they can decide that, okay, let us accept oral statements. You know, they have submitted their written statement. They can decide, oh, let us have oral statement. They can decide to say, let us set time. Can you you should help us resolve this dispute for within 1 week. We want to be sitting every time. We'll take care of the expenses. They can decide to do that. So they have the right to decide that. Unlike the other forms of maybe the court system, they have a procedure, they have rules and regulations that regulate all of that. And you cannot say, I want to hear my dispute and let it be concluded within so period of time. You can only know when you are going to court, but you may not know when you are going to leave the court or when your matter is going to be decided. So you can see that the parties are actually involved in the dispute resolution process. Now, proposal for settlement by the conciliator. Now, you see, that is one of the things that people seem to use, one of the factors that most people use to distinguish mediation from conciliation. They say a mediator does not suggest solution, but he facilitates. He helps the parties reach an agreement, you know, in the resolution of their disputes. But you see, the conciliator here can suggest, he can make proposal for the settlement of the dispute. He can make proposal. He makes suggestions. He proposed, and even when he proposed, you see, the other aspect of it is that his proposal is also dependent on the approval of the parties. So the parties will have to agree that, oh, what you propose or what you are suggesting is okay. So you can see that the decision still lies with the parties. So you can see that mediation, conciliation is just a matter of semantics, as far as I'm concerned. Now, administrative assistance is allowed only with the consent of the parties. In case they need any assistance administratively, it's still something that has to be discussed with the parties. The parties will have to agree, and then that will be done. But when the parties don't agree, that is all. Now, one interesting thing also I also saw in the Arbitration and Conciliation Act is the provision for caucus and joint meetings. The conciliator can actually have separate meetings with each of the parties separately, and then he can decide to have joint sessions with the parties, and then whatsoever he discussed during the this caucus meeting, or yes, especially caucus meeting, he is at liberty, according to the provision of this rule, to actually make it known to the other party. But in mediation, we say that except where the party consents or with the permission of the disputant, the mediator ordinarily will not share the information he receives to the other party, except if the other disputant agrees to it. So you can see that's the only difference we can see. Then the venue are to be decided, is to be decided by the conciliator, but upon consultation with the parties. So you cannot, as a conciliator, just decide, because eventually parties are going to be the one to fix the expenses. They are going to be the one to pay for the price of the venue. So when you are fixing the venue, you consult them so that if it is okay and it's convenient, you know, you now go ahead. And this is what is made. This is the same provision that is made in a mediation session. The same thing. So A conciliator, unlike a mediator, is allowed to disclose information received from one party to the other party in order to, for that other party to offer some explanations. So once you have a private session, you can disclose what you have discussed with this person to the other party, and the essence of it is that so that you want to hear the opinion of this other person about, or you want to hear his explanation as to the things you have received or the information you received from the person you had the meeting with. So each party is allowed to submit to the conciliator suggestions for settlement of the disputes. So you can see, aside from the fact that the conciliator has the power to submit, has the power to make suggestions as to settlement or make proposal for settlement, the parties on their own also have that same power to make suggestions as to the settlement of their disputes. So now, when it comes to the settlement agreement, when the proposal by either the conciliator or the proposal by the mediator is made, and the proposal by the conciliator is made, the parties also have liberty to make proposals or suggestions as to settlement. And when this is done, and then the parties agree on a settlement, this is going to be drafted or drawn out in writing by the conciliator, and then it will be submitted to the parties for their observation and approval. So the parties will have to go through what the conciliator has drafted to see, and then if they have legal representation, for example, maybe a lawyer or a mediation advocate, their role and their responsibility is to look at those things together with the parties and then see if it is okay, if there is any observation, and then if there is none, they will approve that, and then the final terms of settlement is drawn. And once that is done, the parties sign the terms of settlement. That ends the dispute. Now, just like mediation also, conciliation has confidentiality. Confidentiality in the sense that both the parties and the conciliator are to keep all matters relating to the proceedings confidential, except for the purposes of implementation and enforcement of the terms of settlement. That is exactly what is obtainable during mediation or in mediation sessions. So once the settlement agreement is signed and the party by the parties, the proceeding comes to an end. Well, you see all these provisions all these things are provided for in Article 1 to 6 of the Arbitration and Conciliation Acts of Nigeria, Laws of the Federation of Nigeria 2004. Now, resort to arbitration or other judicial proceedings. Now, perhaps if maybe the proposal for settlement and then the suggestion is not acceptable by the parties, and the parties decide that, oh, their dispute is not settled, they also have options. They can explore arbitration. For example, they can also explore other judicial proceedings. They can decide to go to court. So you see, it's all dependent on the parties. They will discuss their disputes. They come to a point where they reach an agreement or settlement. And then if that happens, that brings the matter to an end, the dispute to an end. But where they are unable to settle, it means that they can explore other options, including arbitration. And the same thing is also provided for in the process of mediation. Where parties don't settle, they have the option to explore other means. In fact, some agreements, some contracts, they state that, oh, where there is dispute,
Isaac, Isaac, you want to come in? Nanchang has
first explore
okay, he's here.
negotiation phase, maybe arbitration before. Okay.
Yeah.
Okay.
He's back.
Yeah, he's back.
Okay. Oh, you were not hearing me?
No, we were hearing you. You just for a split second you had frozen.
Oh, okay.
It's okay now. Yeah.
Okay, that's fine. Okay, so what I'm saying is, I don't know, where did you get
No, we heard the whole thing. We heard the whole thing. When you came back, everything came back. Yeah, everything came back.
Okay. So what I'm trying to say is that where parties are unable to settle, they have the option of going for
we heard that.
arbitration.
Yeah, we heard that. Yeah,
okay, that's
we
good.
heard that.
Now the cost of the conciliation session is going to be borne by the parties.
That's
the
okay.
Parties will,
that's okay. Yeah, you were coming to the next one. I like this next slide on the central model, or you were showing that.
Okay. Well, okay. So now, having discussed that, the current trend in the mediation sphere is that we have the ancestral model law on international commercial mediation and international settlement agreements, which are resulting from mediation, and that was made in 2018. Now, if there is any confusion as to whether mediation and conciliation is one and the same thing, or whether it is different, I think this law is going to be of great importance. And what is the provision? It says that this law is actually drafted, the UNCITRAL has drafted this model law in relation to international commercial mediation, which can also be a guide for drafting a mediation law applicable to domestic mediation. So it's actually for international commercial mediation, but it can be a guide for countries that wants to make their own laws in relation to this. So what's the provision of this law? So the model law provides that for the purposes of this law, mediation means a process, whether it is referred to by the expression mediation, conciliation, or an expression of similar import. So there are different ways you can make reference to whether it is mediation or conciliation. What this law is saying, it is the same. There is no difference. So whether it is of similar or similar import, whether parties requested a third, whereby parties request a third party or persons, the mediator, to assist them in their attempt to reach an amicable settlement of their dispute arising out of or relating to a contractual or other legal relationship. And you can see that is what was provided for in that Conciliation Act, that parties have the right to explore and appoint someone who will assist them resolve their disputes. And you can see contractual or other legal relationships. So the mediator does not have the authority to impose upon the parties a solution. So whether it is conciliation or mediation or whatsoever word it is used to qualify it, as long as the third neutral party does not have the power to impose a solution on the parties, that is regarded as mediation. That's the provision of this law. So now we should note that the model law clarifies that it is previously and that in its previous adopted text and relevant documents, UNCITRAL used the term conciliation, with the understanding that the terms conciliation and mediation were interchangeable. So there is this understanding that, oh, whether it is conciliation or mediation, they are talking about the same thing. So you can actually interchange it. Maybe it's just the same thing, just interchange it. So that's the understanding. But for the way mediation is going, and then because of the issue of enforcement and all of those things, they needed to be specific and to clarify the misconception. So the bodies of information or the text that they had previously carries conciliation, but they are trying to explain the fact that whether it is conciliation or mediation, they are referring to one and the same thing. So in preparing this model law, the commission decided to use the term mediation instead of an instead in an effort to adopt to the actual and practical use of the terms, and with the expectation that this change will facilitate the promotion and heighten the visibility of the model law. So this change in terminology does not have any substantive or conceptual implications. So whether you see conciliation in the initial documents or it is mediation, they are trying to say it does not have any contextual or any implication that affects its meaning. It is the same thing they are referring to. Now, we also have another development. The ancestral law was made in 2018. We also have another development in 2020, which is the United Nations Convention in International Settlement Agreement resulting from mediation. It is called the Singapore Convention. And you know, the interesting thing is that many countries are now signing up for this Singapore Convention, and some have domesticated and ratified it in their own countries. So you see, what is the definition of mediation according to this convention, the Singapore Convention? Said mediation has been very appropriately defined in the Singapore Convention in a very broad manner as a process, irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their disputes with the assistance of a third person or persons lacking the authority to impose a solution upon the parties to the disputes. So whether you appoint a conciliator or you appoint the person and you say is a mediator, or maybe a friend who is helping you to resolve your dispute, no matter the name you want to call him, as long as this person does not have the power to impose a solution on the parties, it is referred to as mediation. So the purpose of the convention is to facilitate the cross-border enforcement of settlement agreements concluded as a result of mediation process in relations to international commercial dispute. Mr. Vikram, are you with me? I hope I have not gone up. Hello? Hello?
Yes, I can hear you.
No, Nanchang,
Okay.
I'll tell you what we do, because right now we might get short of time. We'll come on to the Singapore Convention in terms of what the convention does later.
Okay.
But the important things that you have picked out, let's just discuss that, because
That's fine.
because
I think I'm even done. I'm done. Yes.
Yeah,
done.
because of course the settlement agreement and how it has to, I mean, all this aspect, of course, in the law, the domestic law, that we'll take it up. If you want to take 2 minutes to talk about it, please do that, because I don't want to get short of time, because I'll tell you, I want to show you something important. Why I want to show, I want to show, one second, but I'll tell you why, what I want to show you. I'll just show you that.
Okay.
You will shut your screen for a moment, because in your definition of mediation and the clarification in the model law, that the 2018 model law, there's a very important term mentioned there.
Yes.
Which is the clarification that they give. I just want to just for a second show you that. Obviously you pointed it out. Let me just show you that. This is the important one. Yes, Nanchang?
Yes.
You said in its previously adopted texts and relevant documents, UNCITRAL used the word conciliation, right?
Yes.
So now let us look at that document, because the why we have to do that is because when we look at your Nigerian law, first let's look at your Nigerian law. Also, let me tell you, Nanchang, that your Arbitration and Conciliation Act has been changed now. The bill has been passed. It's called Arbitration and Mediation Act. Only thing is, we are waiting for your president to give his assent to it. So whenever that happens, okay. So this is what your current law looks like, right?
Yes.
In the law, you have this right. Now, what you have to do is, at the same time, I will keep opening in 1980. What was the model law that, or the rules that the UNCITRAL had given? Okay, this was in 1980. This was what they had given. So you can read each of them here, and at the same time, you can read your law. Exactly the same. Okay, exactly the same. Sure. You've taken it from there. India also took it from there. Okay, so now the situation was, they have clarified very nicely that we were using that word, Now we're not using the word because mediation has become, the word has become more popular. So there is no change in the substantive aspect, which is what we have to put across. I won't take you through the whole thing because it's exactly the same. You look at your Nigerian law, exactly the same: appointment, submission, role, representation. I show you here, it's the same appointment. There's no difference. So I'm going to say the same thing for Nigeria, India. The situation is the same. So now important thing is to put across is that you have a potato situation. Okay. Now, how long can we keep fooling people on this potato? You want the user to use the process. That is what we want. And what is the difference? And why you showed the definition in the Singapore Convention. I sometimes think you've taken it from my website, because that's exactly what I say there. That has been defined in such a broad manner. All that you have to look for is that the person should not have the authority to impose a decision or a solution. That's all we have to look at. So the way conciliation is provided for in your law, does it fit into the definition in the Singapore Convention? Absolutely does. Because today Nigeria has signed the Singapore Convention, and if your act gets the assent, you would have ratified it also. So when the definition is available to us, I haven't seen your current Arbitration and Mediation Act.
We're still looking for it. Looking for it.
It's lying with your president, so maybe they're waiting for the assent and then they'll release it. I don't know, whatever. So, but the main thing is that the mediation definition is available to us under the Singapore Convention. And if Nigeria has signed it or India has signed it, in principle, we've accepted that definition. So if we've accepted that definition and conciliation as it stands today in your law, I'm saying a new law is already ready. It's just a matter of time before the president gives his assent. But for a moment, let's say the current law, it's called conciliation, but it fits into the definition of mediation. Why are we confusing the user? Why are we trying to tell them we don't have a law on mediation? India was doing that. We also have a bill lying in parliament. So the point is that this concept for the user, they don't understand. For them, it's important. What is important? That someone assists them to resolve their dispute. That's all they're looking for. They are only wanting to make mashed potatoes. You give them potato or give them potato, it will make no difference to their lives. So I think this is what we have to highlight, that the distinction that people have tried to make, I think has done disservice to mediation. Because people do not, I'm telling you, in India, people have been told that there is no law on mediation, when we have exactly the same thing that you have. Exactly the same thing. Only difference is in your law that settlement agreement is not as good as a court decree, as I understand. But in our case, that settlement agreement is as good as a court decree. So that we are at a better footing, I think, but we'll have a look. That's what my understanding of your law is. So I'm just saying that we need to understand that. Okay, Isaac Nanchang has gone. What are your comments on the matter?
Okay, wow. Okay, great. My view may be different from yours and what you have in. I think conciliation, per the readings I've done and what I've seen, it is more like the mediator takes an active role in the resolution of the cases. And when it comes to mediation, although the mediator takes an active role, but the conciliation is more active than the when you are doing mediation.
Isaac, look at you. Isaac, you saw what Nanchang did. He came with support. You have to show us that support. He came with definitions.
Yes.
He came with the law. You can't. Isaac can't just come and make a statement. Where are you coming from?
Yes. So even if you look at our act was so specific on the act I sent you some time ago, the AD Act 798.
Do you have
if
that?
You look at the part,
do you have it in front of you?
The part 2.
Do you have?
Yes, I have it here, but it's not. I'm using phone, so I cannot project it.
Okay. You want to send me the link? Just send me the link. Just send me the link right now. I'll open it here.
Okay, let me send you the link.
You had sent this to me at some point of time. I know. You had.
Okay. Yes. Yeah. I'm sending it to you.
Okay. So basically, is there a definition of mediation there?
No, our act did not define a mediation, what a mediation process is. I did not specifically define. It only defines
You
the
haven't sent me
person,
the
the mediator.
you haven't sent me the link. You haven't sent me the
I've
link.
sent you.
You sent me the
Check.
yeah, you sent me. I mean, in the sense you sent me the okay, you sent me not I mean, I'd have to copy it. That's the only thing. You haven't sent the
Yeah,
link
yes,
as in,
open it. It will
yeah, I'll
come.
do it.
Yes.
I'll do that. No problem. Yeah. So what you saying?
Okay, so I was going to mention the section 30. So they added conciliation, just one section for conciliation under the arbitration part of the act, where they said that the conciliation conference, the heading is just a conciliation conference. If you look at section 30, and they said the appointed authority or any institution or individual may, with the consent of the parties at any time during the arbitration process, arrange a conciliation conference to facilitate the resolution of the dispute, except that an arbitrator in the dispute shall not be a conciliator.
That's okay. But the main thing, where is the definition of where is conciliation provided for? Because we have the same thing in our act. We have the same thing in our act, arbitration act.
I'm saying that when it comes to our act, the issue was they were more concerned about the personality, the mediator, arbitrator, the conciliator, but not the definition of the process. So they did not define what a mediation process is.
Where does conciliation start? Which section?
Look at section 30.
No, that 30 is there. In our act also, arbitration act 30 is there. That is just saying that if there is a settlement.
Look at section 30 talks about, yes, the conciliation.
We have to talk about where is conciliation provided of. Let us look at this.
Conciliation is not provided as part of the act as a standalone.
So let's look at mediation. Let's look at mediation, because that problem, I tell you what is happening is, Isaac, we had a little short of time. So that's why I was trying to look. The only problem is that the next session might not happen. So we might be able to continue because Maureen has some, there's a storm where she's staying. So her internet connectivity might not be possible. So we might be able to continue, but at least if she does join, so we might have to go into that session. So that's why I'm trying to just go through it a little quickly.
Okay, that's fine.
So where it is in mediation is not defined here.
Yes, so let's go to interpretation.
No, but first of all, let's just look at mediation.
Yeah, so when you look at the part 1, the mediation 63, it does not define the process there. It just talk about how you can commence the process. Look at the 63.
Because the thing is that this is exactly what the current model law also says. It's taken from there. That's all. They haven't given a definition for it. That's all.
Yeah.
So there's no definition today. The only thing you are showing us that there are 2 words used. There is conciliation used in section 30, and there is mediation provided for separately. That's all you're saying.
Yeah.
Right? Because this is, what you do is you go through the mediation, the model law, Conciliatory model law, and you see the things from there. So there's no difference in this.
Yeah. No, this is like a copy and paste of the Conciliatory law. When you look at the Ghana Act,
exactly.
It's
So
like
it doesn't. We have from the model law. We've already what Nanchang has already shown us that the Conciliatory itself is saying that there is no difference between the two. So if we are adopting a document that they have provided, and in that document they have clarified it, but we are very smart and we take out the definition of mediation from that model law to confuse people. We could have made life easier for them. No, we have to make life difficult for them. We will take out the most important part from the model law, the definition. We'll take out the definition only. Some of it, the user is not, I mean, a user wants to have things very simplified, but we don't want to simplify for them. That's the biggest problem that these laws do. So right now, what the situation is that because Ghana has also signed the Singapore Convention, so the definition today for mediation is only for Ghana available in the Singapore Convention. You don't have a definition in the Act. So we'll have to go to the definition, which Nanchang has also shown us. I can show it again if you want. What does it say? Basically, it's a very broad definition, which of course Nanchang has taken us through. I'll take you through that also again. And it's so nicely put there that this confusion goes away. You have to read from here, right? A process.
No, even,
For a moment,
okay.
For a moment,
Okay.
because we have to, because today that is for be it Nigeria, be it India, be it Ghana, all three have signed the Singapore Convention. All three
Okay.
do not have any definition in the law. So
We have a definition. That's why I'm saying that when you go to our interpretation, look at section 35 of the link I sent you. 135. 135. 135. Yes.
Give me 1 second. I'll just open.
Yeah.
135. Okay.
Yes, 135.
Yeah, but what I'm saying is that the important part is that the person should not have authority to impose a solution, and that's kind of what it is required. After that, how you do the process. Yeah, so now the definition of mediation. Conciliation means a submission. Okay, let me share this. Because we have some time, it seems that Maureen might not be able to join us.
Okay.
Yeah. So we've got conciliation. This is which is important. This is in an arbitration. In an arbitration, you are going in for a process where the not the arbitrator to facilitate the resolution of the dispute. Okay. The conciliation in your law is while arbitration is going on.
I think you are okay. Was it 135? Are you there?
Yeah, 35. I'm looking at conciliation under 135 definition, which is very important. What Ghana has done is exactly what I've been talking about, and I'll show you what. Okay, now let's look at whether there is mediation. Means a non-binding process under Part 2 in which the parties discuss the dispute with an impartial person who assists them to reach a resolution. So between your conciliation and mediation, there is no difference except conciliation is if it is part of the arbitration process, mediation is outside. And this is very, very important what you have done, and which is what I've been telling people here also, that we need both the words. I'll tell you why we need both the words. Because in an arbitration, if you are going for a settlement, whatever the name of the process, right now we won't even call it conciliation. You go for any process for settlement and you are able to settle it, you will come back to the arbitrator and ask the arbitrator to pass a consent award. That consent award is enforceable under the New York Convention. So parties would want to stay in the arbitration. Now, if you do not want to be part of that arbitration, you want to do it separately, then in that case, you will go under the mediation provision.
Yeah.
Now that mediation settlement agreement, what is the status of that?
If that after when you get a mediation terms of settlement, that one it becomes a binding, which is under it recognizes as part of similar to an arbitration award.
Exactly. So same thing that we have done, the same thing, no difference, because it is as good as an arbitral award. So it is as good as a court decree. That's the situation. So the same situation we have. So very nicely what you've done is really important, and which is in our section 30 of our Arbitration Act. It says that of course it is like a duty of the arbitrators to see that if there can be a settlement through mediation, conciliation, or any other method. So I've been saying that those two words are very important, because if the parties want to stay in the arbitration, in that case, in your case, it will be conciliation, and you stay in the arbitration and get an arbitral award. If you go into settlement through the mediation, you get what is as good as an arbitral award, and it is as good as a court decree. Because once you ratify the Singapore Convention, then in that case, something which is
it'll go under.
It'll go under the Singapore Convention. So that is why those two processes are very important, which people are not being able to understand today. They're going again in our country. Oh, we have conciliation, that word. We know everything wants to go. We have to remove conciliation from the law. We want to call it only mediation. This problem is going to come up, because finally, if up till Singapore Convention is not ratified by lots of countries, up till then the New York Convention, definitely with its possibility in so many countries, People would prefer to stay there. So then you are confusing the situation, because you're saying mediation is a word used in arbitration also. It is a word used outside the arbitration also. So if a person gets that consent award, the other country where you're trying to enforce it will say, no, this is not under the arbitral. It's not an arbitral award. This is actually you have to enforce it if you were ratified the Singapore Convention and under that. But we haven't ratified the Singapore Convention, so you can't enforce it here. What these kind of issues will come up. So I think what you've done is a very good thing. I think what you've done is very good. I think, I don't know, look, let's see what Nigeria has done, because we don't have the law right now in front of us. But the general understanding of the whole matter, which is what we've been discussing earlier, and Isaac has, of course, heard me talking about this so many times, is that this potato thing is actually finally confusing the user. That's all. The user doesn't understand these intricacies of the law. They are not supposed to be legal professionals to interpret the law. They are sitting, so one person is sitting in a village in Ghana or Nigeria or India, and you tell them, first you go get a law degree to understand the law, then we will give you the law. Mediation has to be such a simple law, so simple. And if you look at what he showed us from the Nigerian, those today, what that act says, because that act has changed today. I mean, in the sense it hasn't got the assent, but what is how it is put there, which is taken from the model law, is very simple to understand for anyone. A layman can also understand it. This is the process. You reach out to the other side. You have so much time to accept. Then you appoint conciliator 1, 2, 3, whatever, and then the process that how the conciliator has to go about the process. So nicely put, which is what we have. I haven't right now looked at the Ghana thing totally, but I think it must be the same situation. Is it as simple there also process? Yes, Isaac?
Yes, come again.
Your mediation process is also is taken from the model law only?
Yeah, the process is outlined under the section 63, as I showed you. Yeah, how you can initiate a mediation process.
Yeah, it's exactly the same thing as the model law. So exactly same thing. So it's so nicely put. It's no simple. So such a simple thing that is what we have to actually bring it out separately. That would have been the best thing. Keep it as a separate law, which can be circulated to the country, that look, we have such a nice law that you can go get into a settlement agreement, and it is as good as a court decree sitting in your village in one corner of Ghana or Nigeria or India. No requirement of going to the court, no requirement to go to the government, nothing. This is what we need to highlight all over the world.
Sure. Yes, sir.
So that's how it is now. Nanchang, what do you think?
Nanchang is back. Yeah.
Yes, Nanchang.
Yes. You know, my concern has been, assuming you go under the Arbitration and Conciliation Act, and then you appoint a conciliator, and a dispute is resolved. When it comes to enforcement, is it going to be enforced under the Arbitration and Conciliation Act as an arbitration?
Oh, this is where the problem with the Nigerian law is, that Nigeria has not provided for what Ghana has provided for and what India has provided for. That settlement agreement is as good as a consent award. Those words are missing from your act. So it will be as good as a contract. Because so you can't enforce it like a court decree, which is what I understand. This is just a quick reading of it. I'm not saying that you have to quote me on that. You can have a look, but when I have looked at it, I have not found this provision there. Because up till
it is not there.
Yeah, so up till you don't put
even when you come to Ghana, when it comes to even arbitration award and even mediation terms of settlement, yes, once you have that, it is binding. But if you want to enforce it, you have to go to court through motion to enforce that.
Look, enforceability is a word used, which is obviously a contract is also enforceable, and you can enforce a court decree also. Both of them are enforceable. It's just the process in the court. If it is a contract, then you file a suit, and then that suit obviously takes a long time. And if it is a court decree, as good as a court decree, it is, of course, enforceable as a court decree, which is much faster. So that is why that provision was required. And I hope that the new law that you have come out with, the Arbitration and Mediation Act, hopefully has that. Let's have a look when it comes out. I mean, whatever. So
Sure.
I think the general thing, Nanchang has, I think, covered the broad things there, that the model law and the provisions in the act and everything nice, simple. So I think this is what the user has to be told, that look, don't get into this technical thing difference, because like Isaac was saying, that it is a mediation is a facilitative process and conciliation is an evaluative process. Where do we get it from? Neither his law has that. His law doesn't have say something like that. But because there is some person sitting in some corner of the world, somewhere Isaac read this. And he says, look, this is what I've been told. How does it work for the user like this? I can't go and make a statement to a user, no, it is like that. And how it does it even matter to them? They are out there to settle their dispute, and they are not getting into these models of mediation, facilitative, evaluative, transformative, evaluative, narrative. They're not interested in all that. They don't even know about that. So this mediation world between itself keeps having these discussions, theoretical, academic discussions, which the user has no concern about. The user has appointed their conciliator or mediator. If they are not happy with the way the person is doing it, they will walk out of it. It is not a process that you have to stick in it. If they don't like the approach of the mediator or conciliator, they'll move out of it. So where is the reason for us to keep confusing the user? For them, it is not the word that matters. It is the process that they are going through. So if they are comfortable with Nanchang telling them that, okay, I think this might be a good solution, there's no problem if they want to hear you. If they say, no, Nanchang, don't talk to us about solution. You are not supposed to talk about solution. Okay, I don't want to talk about the solution. Where is the issue in that? As long as the important thing is you do not have the authority to impose a solution. That's about it, nothing else. Because I'm telling you why this aspect is required is tomorrow, if supposing the law said that the conciliator or the mediator cannot make a suggestion. Supposing you say that. It is now this is a confidential process happening somewhere. Tomorrow there's a settlement agreement and they say, no, this is what the mediator suggested. And they are not supposed to suggest. I mean, come off it. Who was ever going to prove whether the person suggested or not? Finally, the important thing is that settlement agreement is being signed by you, and it is your decision. It is your agreement, and whatever suggestions might have been given to you, the person did not have the authority to impose it on you, and you did it on your own free will. That's all that is required. So I think that's
okay, Mr. Vikram. Yes. I think one of the issues on ground is the fact that, even if in the present state as it is here in Nigeria, assuming you go for mediation or conciliation and then a terms of settlement is reached and then is signed by the parties. Now you see the process of enforcing it as it stands here in Nigeria will still involve you going back to the court, except in states like in Nigeria where you have multi-door courthouses, and then the multi-door courthouses are actually attached to the court, most times within the court premises. And then we are saying that we are promoting an idea where people can independently decide to resolve their dispute outside of court. That is what we are saying mediation is. So if you resolve your matter outside of court, shouldn't there be an avenue or a platform where you can actually go to enforce this thing independently without the need of going to the court?
Look, let's first of all understand what enforceability is. The settlement agreement is signed outside the court. Okay. Today we have to go by your present law. We don't have an option there. So we go by a current law. So this is a process which is happening outside. At the end of it, a settlement agreement has been signed. So nothing, there's no enforceability required, because if the parties are going to follow what they had signed, there is no requirement to do anything.
Of course.
I had to, under the settlement agreement, pay you a certain amount, and I pay you that amount. Maybe I was supposed to pay you in 3 months. I pay you in 3 months. That's the end. Now, there is no requirement of any. Now, it is the only issue is that after 3 months, you do not pay me. And obviously, it's the contract. So under any contract, you will send the person a notice. saying that you were supposed to pay this under settlement agreement. Then if they don't pay you, and if it is only a contract and it is not as good as a court decree, then you will come to court and then you will file a suit. So in your case, you'll have to file a suit because it's a contract. In our countries, if we have, because in our case, the conciliation in the case of Ghana is called mediation, but this is outside the court. It's not connected to the court. So it is as good as a court decree, and you will come to the court to enforce a court decree. That's all. So I mean, there's no issue. The provisions are there only because your law in Nigeria missed out on that very important sentence, which said that this settlement agreement is as good as a consent arbitral award. And then you go to the provision for the arbitral award, which says that the arbitral award is as good as a court decree. So that link is missing in your law, which hopefully in the new law might have been taken care of. That's how it is.
Yeah, so but as it stands now, my concern has always been parties who you discuss and help them see that you can resolve your matter out of court. Where a party, because people always raise this concern, what if this person refuses to abide by the terms of settlement? What happens? You know, you will have to still come to court. So, but you have already told them that this is a process that is done out of court. Is it possible to now have maybe an institution, an agency that is responsible for enforcing settlement agreements or terms of settlement outside of the court? Or you still, maybe it becomes like a necessary evil, having discussed and settled out of court, you have to still come back to court. And then that aspect of, okay, when you go and you want to file a suit in order to get this matter, the terms of settlement enforced, that's another suit, that's another court proceeding, that's another process. So what's your take on that?
Look, Nanchang, first of all, whenever parties talk about it, then you tell them, look, this process is such that after all the discussions and everything being looked at, you have got into a settlement agreement which is acceptable to both of you. No one has forced you. If Nanchang is carrying a gun with him and put them on their head, then that's a different thing. And I don't know what kind of mediator you are. Maybe you put guns to their head. But hopefully you're not like that. So now it is the party. They have looked at their present condition. They've looked at all or whatever the situation is. And then they've entered into this settlement agreement. So this requirement of saying that, okay, the enforceability we keep talking about, then maybe they're in the wrong process. That means the parties are just trying to waste each other's time, because the settlement agreement is supposed to be something that you have understood that, yes, this works for both of you. If I cannot pay you in 3 months, I don't have any money and I have no access to money, and I get into a settlement agreement to pay you in 3 months, then I am fooling you and I'm misleading you. I'm just taking that 3-month time. So in that case, anyway, my intentions were not good. If my intentions are not good, then how does it matter whether that settlement agreement I enforce as a contract after 3 months, or that particular arrangement that we had today, I enforce that? I have to enforce it. So if someone is wasting someone's time and they are saying that, okay, I will, whatever, I'm just giving you an example of payment of money. There could be various kinds of settlement agreement. But supposing the person takes a 1-year time because the person is just trying to buy time. In those kind of situations, who's going to be able to help anyone? Your only advantage, I told you, is that if your law says that it is as good as a court decree, that's all. That's the missing link. That's all that was required. So you can then tell your parties that, look, if supposing this person doesn't follow whatever is they put down in a settlement agreement, you go to court and you say you have to enforce a court decree, which is a very fast process. A suit, I don't look, now this depends on country to country. In some cases, suits might take 20 years. So that is the difference. You'll be able to show them that this is, if the court decree, this is the time, and the advantage of that is that you do not have to file a suit and go through that route. So just don't worry, Nanchang. According to me, that this new law that has come out for you will definitely they would have looked at this aspect. So let's just hope. Let's just hope.
Yes, even Vikram, to add to what you are saying, even when it comes to Ghana, enforcing terms of settlement or outcome of ADR process is not all that difficult, and it doesn't take much time. It can take a maximum of maybe just 3 months, or within just a month that can be done. Because what is important is the initial filing process. If that is done, they just one sitting or two sitting, a judge can give a consent judgment, and that is the end. So
Exactly.
it's not difficult like the normal court process whereby you move up and down, because this one, you have already determined the outcome and everything. So the court will just look at the thing to know. Yes,
Isaac, only because of that one sentence in your law. I haven't read the law, you told me. Only
Yeah.
because that settlement agreement is as good as a consent award. Only because of that one sentence, it becomes as good as a court decree. That is why the time gets saved. Otherwise, it would have been a contract, which is the problem in the Nigerian case. It is just a contract because that they removed that one sentence. For what reason? I don't know. Because if they are taking a model law, why do your editing sitting at home? I'll tell you what the problem is.
It was a typographical error.
No, this is intentional. This is the colonial mindset I talk about. They don't want to give the power to the people. Why should we give them the power to make a court decree sitting in their village? No, we have to be involved in it some way. That's where the problem lies. Otherwise, this is intentional aspect of it. No one wants countries. The colonization mindset is not going to go out so easily. We have to have control everywhere. We have to be into the lives of people. If they do not come to us, they won't value us. So those are the things they are fighting against. Hopefully, look, let's just hope, Nanchang, that now that thing is gone. The new law, they've understood it, and they've been able to put this at the settlement agreement is as good as a court decree. That problem will go. So let's wait for that, because I don't know how much time it will take. When was it passed? In May only, na? I think 22nd May.
Sure.
When was the?
Sure. Yes, it was in May.
May. So basically, it says on 10th May. 10th May it was passed. So how much time does it take for the president to give assent? I don't know. Normally it should not take time.
Sure.
So hopefully we'll be able to get that now. So anything else, Isaac, Nanchang, you would want to add to this?
Not really.
Perfect. So main thing is, let's not confuse the user. Let's not keep telling them mediation, conciliation, facilitative, evaluative, this, that. They're not interested. Let's just get people into the fold. Let them use the process. I think that's more important. So anyway, anything on closing, Nanchang? Let's let Isaac close, then you get the final word. It was your topic. Yes, Isaac. What would you like to say?
Okay, so let me say a big thank you to Nanchan from Nigeria and to you, Vikram, for organizing this event. It's been insightful having a discussion with all of you. As you said, there's a need for us not to confuse the end user, because communication is key. Once we are confusing them, they don't know which one to use, and they will still go back to the normal process that we are trying to save them from. So thank you for the opportunity.
Thank you, Isaac, for coming in. Always a pleasure seeing you. Yes, Nanchang, you want to just some closing remarks?
Okay, let me first of all thank you for the conference. It has been going well. We appreciate your effort in the organization. Thank you also for the opportunity to present on this topic. It has been something that a lot of people, lawyers, even a lot of ADR practitioners or mediators are ignorant of course, and then when it comes to selling the idea to people, knowing that they have an option to explore in the resolution of their disputes, they find it difficult because of some of these misconceptions. So, this thing is not binding, it's not enforceable, you cannot do this, you cannot do that. So, but with this, and with the ancestral and then the model law that we have seen that those misconceptions has been clarified. And then we are hopeful with the passage of the Arbitration and Mediation Act. We hope that some of these misconceptions will be put to rest. And if that is done, I think ADR and mediation is going to be one of the most effective ways of resolving conflicts and disputes in the whole world. And we are hopeful and praying that the president in Nigeria will sign this, and then it will put to rest some of this contention, so that even lawyers who are opposed to the idea of mediation, because of its peculiarity, will actually see it as an option. And then that will also boost their practice, because I believe that clients are interested in the results. They are not interested in a situation where you go to court and then you keep battling and battling. After 2-3 years, you got a victory and then you can't enforce it. You can't actually benefit from it because the other party is going on appeal. And then he goes to the Court of Appeal. From there, he goes to the Supreme Court, and matters staying 10, 15, 20 years. In fact, some of the cases, you see that the parties who institute the matters are dead. And then the children take over hostility from their parents, and then they continue like that. I think this mediation is going to be the way forward, and then it's going to bring about world peace. And it's all about dialogue, discussion. We have disputes, we have misunderstanding. Let's talk about it. Let us know your own idea. Let us know what your aspect is, what you actually want. If that is okay with me and you agree and you put to rest, and then where this is not done, that is where we continue to have conflict. So I believe that mediation is the future of dispute resolution. And then we hope that all the countries in the world will get to sign the Singapore Convention on Mediation. And then that will set it on a pace like the arbitration and its enforceability. Thank you. Mr. Isaac, is he still with us?
Yes, he's always with us. He's always with us.
In spirit,
he's always with us.
Please help me send you send me on your contact or number, and then that your law that has to do with mediation.
He'll link with you. He'll link with you. No problem. And you have your good thoughts on everything. Thank you, Nanchang. Important thing you have to tell people is that you're not stopping in getting into contracts, are you? Supposing your law takes time, in your current law also, if it's just a contract also, aren't you entering into the contracts all the time? So to say, no, I won't get into a settlement agreement because it is just a contract, I think again someone is fooling them. Contracts.
No, but I think, Mr. Vikram, I think we have multi-door court houses which are actually into ADR, alternative dispute resolution, and individuals who have terms of settlement can actually walk in there without the need of even a lawyer. They can walk in there. This is what we agreed, and then for Lagos, for example, we have ADR judges who are designated, and then they just look at these terms of settlement, and then within the shortest time possible, they put it into. But our concern is that these multi-door courthouse are not all over, and then some are not effective as they should. So, but we are hopeful that with the passage of the new law, some of the states who do not have the multi-door courthouses will begin to
I think Nanchang, what you have to understand is that we have to understand your multi-door courthouse. Are you saying that a person who files a matter in court and it is sent to a mediation center in the court, the settlement agreement in that matter then goes to the ADR judge and based on that passes an order? Are you saying that? Or are you saying that a matter is not in court and the person goes to the multi-door courthouse, does not file any case or suit or anything in the court, and goes to the mediation center, enters into a settlement agreement, and that settlement agreement is then sent to the ADR judge? What is the system there?
Yeah, the system is that the multi-door courthouses are exclusively ADR centers. And an individual on his own who has a dispute or an issue can go in there and say, this is my issue, and then they can take it up without the need of going to court. They can invite the other party, they will fix a time where they will sit and discuss. And then once they reach an agreement, that is enforceable because they already have designated ADR judges who these matters will be assigned to. But on the other hand, there are people who already have a terms of settlement. Maybe they have discussed and they agree. They are going to the multi-door courthouse only for the purpose of that settlement agreement to be converted into a consent judgment that can be enforceable by the ADR department, you know. So an individual can do that. So it's either you walk in there and file your matter, not in court, or you have a terms of settlement and you go for the purpose of that terms of settlement to be adopted before an ADR judge to become consent judgment, which will be enforceable.
Are you seeing some very big problem in this? The problem that I am seeing in this is that anyone who doesn't have any matter in court can go to the multi-door courthouse, pays $40. That's all. That's $40 for the entire mediation, and can gets a mediator appointed. And that that settlement agreement, whatever process after that, I'm not concerned with. That means private mediation is going to be finished. If in 40, obviously, this is what I'm fighting. Nanchang, this is what I'm fighting against. I'm fighting against this. You are saying that you should have multi-door courthouses in every place. I am saying that mediation should not be allowed like this in court, because how are we going to survive? What are we going to survive on?
Well,
even Fola, even if Fola goes to the multi-door courthouse, he will only get $40. He's not going to get more than that. Can you imagine that? Okay. Ask him, and you don't know how many sessions it will take. So is he willing to keep that as his practice? Can he survive on that? It's a big problem. Well, this is a big problem. We have to fight against this if we are to develop mediation. If we are out there to serve the purpose of the judiciary, then let the judiciary give you as much as the judges charge. Whatever the salary of the judges is, every mediator in the country should be given that amount.
Wow, that would be very difficult.
What else? You are helping people. The judge in the court is not even helping them finalize their matter. It will go in appeal, like you said. A settlement agreement which is entered into mediation will close the matter. So the person, the mediator, should be paid more than the judges. So do that then.
Yes, ordinarily. But you see, the issue is that a lot of people are not even aware of the process. So when you begin to talk to them, even lawyers, the unfortunate thing, many lawyers don't even know about mediation. So that's the difficulty we have around here.
I tell you, Nanchang, they know everything about mediation. They don't want to send people there because that's your pension, 20-year pension. I'll tell you a very interesting story. This was 2 years back. Fola had done, he called me for some, like, let's call it an interview. I don't like to use interview, just a conversation. So he'd called me for a conversation and we were talking about this. Then he said, there is this, I was telling him there's this story that how this father runs a law practice and then his son comes into the practice. So one day the father doesn't go to court, the son goes to court and he settles the matter, is closed. He goes to the father very happy. Look, I've settled the matter. Father gives him one thrashing. He said, that matter is the one because of which you have studied so much. You have bought the car that you have and you've gone and settled it. So that is, he said, oh, you were telling me this story. This same story is what we tell people in Nigeria also. So this is standard across the world. This is the way lawyers are discussed everywhere. So that I'm telling you, in India, here, what are they saying? We don't have a law on mediation. When I say we have the best law on mediation, which is called conciliation. So they will go on. They'll find something else. Some other law comes, they'll find something else in that. So finally, who are we concerned with? Is the user. And we are concerned with the mediator. Both those people should benefit. The mediator is never going to benefit if your multi-door courthouse, anyone can walk in and pay $40 and gets a settlement agreement and goes to the judge, and that is made into whatever decree or what, I don't know what they do there. Whatever. How will mediator survive? Will you be able to practice as a mediator? Isaac and you will only make your money out of training, nothing else, because mediation will not give anyone any money. So it's only going to be the people who are doing the training. That's all. And I don't like the word training. Isaac knows. I'm saying skill development. But that's
yes, that is true. The payment, even especially with the court collected or court annexed ADR people, the pay that they give them is woefully inadequate, unless maybe. And when people get the user experience from the courts and they are using a private mediation session, it's difficult for them to pay because the courts, they are not made to pay any fee because it's part of the court process. So if your case is referred to the court annexed mediation, you do it for free because it's seen as part of the process. So when your case is referred outside the court and you are being asked to pay fee, then they are like, wow, why should I pay for these services here? So there's a lot of education that needs to go down.
Not education,
And
Isaac. Where's the education? This is a
the
system that they've
education is
made.
like
They've
the
made a
structure.
structure. Yeah, they made a structure which who's going to break it down? The judiciary has made the structure. It's their self-interest. Who's going to fight the judiciary? Tell me,
But
any of
one thing
you.
is, yes, but one thing is the judiciary is also not the regulator of the practice. They are only using it to augment their services. So when it comes to Ghana, if you look at the Act, if you look at Section 114 go in the Part 4 of the Act, it talks about the Minister for Justice taking charge of the ADR and setting up a specialized center which will regulate the practice within the country. But that has not been done. You talk to them, they will tell you we are still working on it, but that has not been done. Until that is done, so that they will set up fees and regulations and other things which will guide the process. We will still have the same problem because the court is doing something which will help it to reduce a lot of backlog of cases. So, and that is also good. So if you are not setting up the system well, every institution will use what will be best for them. And that is what you're saying.
So what I am trying to say
Well-
is that finally, if we want mediation to grow, is when people value the process. And the valuing of the process will only happen if they know that there is some look, we are living in a world where how much you pay is how people value things. That's how it seems. Anything.
Well, Mr. Vikram, I think, you know, in this Mediation and Conciliation Act, it actually makes provision for costs. You know, in the Mediation and Conciliation Act, there is provision for costs. It's just that I don't know the current law that is being passed, whether they are going to make specific law as to how much should be paid, because in arbitration, of course, these schedules of fees are actually made. They are very clear. But in mediation, we don't have anything like that, except maybe in India. I don't know if you have anything that talks about fees for mediators, like in arbitration.
I'm telling you, the problem is the same everywhere in the world. The judiciary doesn't want people to pay for mediation, because if they start telling people to pay for it, people will go and file whatever a writ petition or whatever way. Every country has their way. They will say, we had come to the court for the court to decide the matter for us. You are sending us for a process which we did not want, and then on top of that you want us to pay for that process. It will, that in Romania, it happened in Romania. The entire thing was scrapped. I think there's a mediator from Romania whom I was talking to. He's saying maybe there were some 10,000 mediators in Romania. One day, everything got finished because of this aspect, that how can you send us for a process and ask us to pay for that process? And this process should not, I mean, whatever that judgment was, we'll have to have a look at it. The main essence of the whole thing is that if you ask people to pay for a process which is not part of the constitutional aspect of what a court is supposed to do, court is supposed to pass decisions. That's what people go there for. So if you are going to send them out of that process and you ask them to pay for it, they will challenge that. And that is what the risk. No court wants to take that risk because it is a nice way to send off their matters. So they will not take the risk in that. So that's why this thing continues, and no one is going to, from their side, even change that. So we to think that we will get any relief on this aspect, I don't see that happening. So how is going to fight it? I don't even know. Is Nanchang ever going to go to the Supreme Court Chief Justice and tell them, why are you finishing off mediation in our country? Will you be I keep criticizing. I am saying that instead of going and telling people that you go for mediation, instead the Chief Justice of the Supreme Court should fold his hands, go on television and say, look, we are the most inefficient institution in the country. We have not done our job. We are making people go through 20 years of them losing their peace of mind, their whole money, their time, and we are getting away with it because we are a colonizer's institution. We can do what we like. And on top of that, we will connect ourselves to a process which we have nothing to do with. We are a court, which is the adversarial method of dispute resolution. Mediation is a non-adversarial method, which is not in our purview at all, but we are going to get into that also. We are not going to let mediation and mediators develop, because we are going to tell people this is a free process. You don't have to pay anything. They will, like what Isaac said, they will never value it after that. Then the mediator in the court, say in the multi-door courthouse, gets $40. Why isn't a lawyer who works in the court, the litigation lawyer, why is that lawyer also not paid $40? Isn't that lawyer also part of the process? You pay the lawyer who's into litigation, the arbitrator, the mediator, everyone the same. They should not be paid any different. That day, your mediation center in the courthouse, in the multi-door courthouse, will be closed down. Lawyers will close it down. It is just that they are getting away with it because mediators are very decent people. We are not like, we don't like to fight with people. So we say, okay, you are giving $40, no problem. We are very passionate about the whole thing. So we are coming to do it. How long will they survive? They won't be able to survive on that. Either you say that, like I keep saying, that give us saffron robes or white robes or green robes, whatever color robes, and give us some tree to sit under, and that's all. We'll sit there and we will only survive on water. We won't even eat anything. Then it's okay. I'm saying there has to be in a court. Imagine discrimination being done by the court. That a mediator who is providing a service, what is a multi-door courthouse? Everything should be the same. Mediation, arbitration, litigation should be the same. So have the same rules for all of them. If you want to be a litigating lawyer in the court, you will get $40 for a matter. That's it. You want to be an arbitrator, you get $40. You be a mediator, you will get $40. Damn good, not a problem. Try it out. They will never be able to do it because there is total discrimination against mediators all over the world, because they have never. And the point is that most lawyers are the ones who are mediators in the court. They are the ones who are already running the litigation practice. They will come there to, a lot of them in some countries are going there only they get recognized by the judges and they can be made into judges tomorrow, be taken up in the bench. They have that thought process. Everyone has different thought process, but at the end of it, the user is getting a service for free and they are not going to value it. But this is a totally different direction.
I think that's what Fola was saying. He said he doesn't like the idea of free at all.
Exactly. How can you? Well, my point is that how can you even tell people that a service, it's a service that you're providing. A service has to be given for $40 in Nigeria, where it can be as many hearings. I mean, as many sessions. You don't know how many sessions it's going to be. I mean, it's just sad that I can see that. But what I'm going to do right now is that what we'll do is we'll just end this session. I'll just start that session and just tell people that that session is not happening because Maureen has a storm in her place. So internet connectivity is gone. Right. So let me just close this session. I'll start that meeting. I'll start that session on live stream and then we can talk there. No problem. So give me 1 minute. So thank you very much. This conversation is not going to end. I will keep ranting. As I say, everyone says I rant about it. I will keep ranting. But up till the day that we can make mediation a standalone thing outside the court system, people are paying for it. They value mediators more than they value even judges or lawyers or anyone else, because they're actually helping us resolve finally a matter. There is finality to it.